Have you ever wondered what it's like to defend someone, knowing that their freedom depends on every word you say? Or to pull a client out of a corporate war where the stakes are higher than in any thriller? We are practicing lawyers, and each of us has stories you wouldn't share over dinner. Funny ones, absurd ones, touching ones, shocking ones. Today we're sharing them with you, honestly, straight from our own experience. Subscribe, hit that like button, and let's go. When I worked in residential real estate, we had a non-married couple that were buying a house, and everything was going smoothly. I reached out to them on a Friday, which was the last day of the attorney review and inspection period on their contract, to confirm that they wanted to move forward, since it was the last opportunity to back out and get their earnest money back. They wanted to move forward. First thing Monday morning, we get a call from their realtor saying that they had a fight over the weekend and broke up and want out of the contract. Obviously, I need to confirm this with the clients before we take any action that would put them in breach of the contract. I called the number on file. No answer. No response to the email I sent either. The next day, their realtor calls again and says the male half of the couple committed suicide. It was his number and email address we had on file, so that explains the lack of response. We proceed to terminate the contract despite some grumbling from the seller's side, since dead people can't buy property. Obviously, we thought that was the end of it. Then a week later, the male client's wife calls freaking out. Apparently, she had been completely unaware her husband had been trying to buy a house with another woman and just caught wind of it now. She just wanted to be sure that she wouldn't be liable for anything her husband had done regarding this transaction. For an area of law that is normally pretty mundane, it was a lot of drama. I was not prepared for both the amount and various genres of personal pornography I would be exposed to when I switched to family law. I do a little bit of everything: family, general civil lit, and criminal work. There are so many wild stories, but one of my favorites, a client of ours got caught cheating on his wife, and the separation became super messy, so my client had to have the sheriff escort him to the marital home to retrieve his belongings. The sheriff, my client, and his mother show up to get his things out the garage. Upon opening the garage, there were images of my client's dick pics he had sent to his mistress posted everywhere. His wife literally printed hundreds of the photos and stuck them around the garage for the sheriff and his mother to see while removing his stuff. Family law is wild. I've told this one before, but at a family law firm I was at, we had to go into a full lockdown for several hours once. We represented wife in the divorce and order of protection. Wife and husband had an order of protection hearing where the order was granted in favor of wife. As he was leaving the hearing, our process server served husband the divorce documents. Husband was upset at the OOP hearing, but getting the divorce papers caused him to snap. He went to his kid's school and shot wife and her police officer boyfriend, then made comments on social media that he was coming for the attorney who had just returned to our office from the OOP hearing. Immediate lockdown, no one in and no one out for hours. The front of our office had huge glass doors and windows, so we were not allowed to move around the office. After about 4 hours of hanging out in a conference room with the attorneys and staff, almost all of whom had a concealed carry on them, we were given the all clear by law enforcement. The husband had traveled 50 miles away to our defunct SAT office. When he saw no one was there, he got back on the freeway and decided to have a standoff with police that did not end in his favor. The whole situation is sad. Wife and boyfriend survived, but had severe PTSD. The kids were traumatized and now have to deal with the grief of losing their father in such a dramatic act. I've since left that firm, but that is hands down the craziest client story I've ever been a part of. I worked for a small firm doing bankruptcy, and I loved it. We took on a client that owned racehorses and told us she had a head injury from being kicked in the head by one. She had a quirk. She would spell words backwards in the middle of a sentence. She would send correspondence through the mail, and it would be addressed attorney's firm, address city, state, zip, USA, Earth. Because some people mail to the moon, I guess. We have her the paperwork to fill out, and she has so much difficulty with it that she scheduled a time for her to sit with me, and I would assist. We got to the horse values, and no lies. She was telling me they were worth millions of dollars. I would have no way to know whether that was true until she told me they were worth so much because they were going to save the world. Yep, save the world. Who am I to argue? We ended up withdrawing from representation because she would not cooperate at all. And then she started emailing, calling, and just showing up. We finally had to have the police tell her not to come back. I will never ever forget this one. Ever. Husband, 79, and wife, 71, divorce after 51 years of marriage. She had dementia and had gotten violent. He wanted a divorce so that he would not be stuck with the expense of paying for her continued care. She stabbed him with a screwdriver, kidnapped their 67-year-old neighbor who had early signs of dementia as well, and then ran from the police on a 3-hour chase, tackled 2 troopers, and was jailed. She sat for 3 weeks before the judge released her, citing that jail was not the place for her. She had an attorney, but she wasn't competent to consent to anything, and even when lucid, adamantly and feverishly denied a divorce. Told everyone, "We are going to die together. Just watch." He takes her home. She calls the police on herself. Turns out he went and got a protection order against her for criminal conduct. She could be home as long as she didn't break the law again. In the husband's words, she can be home if she behaves. He calls us snapping because 17 months in, and 3 hearings later, the judge denied his divorce claim, stating that "I'm not granting this divorce because you don't want to be responsible for her long-term care, in sickness and in health, till death." 3 weeks later, he has her arrested again. She's put in the hospital and evaluated. Recommendation was long-term care with a locked dementia unit only. Getting her placed took a while because husband canceled her Medicare supplement insurance he was paying for. He starts getting hospital bills for her and loses it. Eventually, an elder law attorney told him that if he stayed married, he would be a surviving spouse and would be able to keep the house. If he pushed the divorce, her newly appointed guardian ad litem was pushing for half of everything and alimony to help offset her out-of-pocket cost for the long-term care. He withdrew his divorce complaint so fast and yelled because he wished we just would have forced her to sign the consents before this all happened. This case broke my heart. After all those years, his only concern was making sure that he didn't have to pay for bills for her care. This one is way more sad than funny. Guy was on trial for molesting his own daughter, charged with sexual battery on a child under the age of 12, which carried a sentence of 25 to life. It was a very short trial despite the stakes. State completed its case in a day and a half. It was extremely brutal, but straightforward. Evidence seemed pretty solid. State rested. The defense was supposed to be that this was a nasty divorce, and mom had warped the kid into claiming molestation. The witness list had a fuck ton of psychiatrists and other expert witnesses, and some were definitely at the courthouse, not in the courtroom, but hanging out. Plus, the defendant was supposed to testify. None of that happened. Instead, the defense asked for the rest of the day to prepare a motion for judgment of acquittal. This is a very pro forma step, usually just a setup for appeal. The judge is puzzled, but says okay. The next morning, the defense attorney was already in the courtroom when we got there. The judge comes in. By this time, the prosecutor had obviously figured out what was going on and desperately pleads to be allowed to reopen her case. Judge says no. Defense attorney distributes the motion for JOA. The state had failed to ask anyone, not the mom, not the doctors, not the police, how old the little girl was. She didn't testify, so the jury never saw her. So her age, which was an element of the crime, was not proven during the state's case. Moreover, the prosecutor had made the pretty ruinous mistake of only charging the capital sexual battery, which had no statutory lesser charges. Just like that, it was over. The guy walked. The little girl was 6 years old. Once I was working with another lawyer on a case as the defense, where a young lad had received funds from a company to restore, upgrade their cybersecurity because they had been hacked. However, the company eventually found out that the guy they had hired to solve their cybersecurity issues was actually the one who had hacked them in the first place. So the company found that they had been scammed and tried to reclaim the funds they had given to the young lad. In court, the judge found that it was more that probable that the young lad scammed the company. The judge therefore asked the young lad whether he was able to repay the company. The young lad told the judge all sorts of incoherent stories and strange alibis, but mainly emphasized that the money was long gone and that he now was, technically, bankrupt. Like the rest of the arguments, the judge was not buying it and kept asking whether he really did not have any money he could get a hold of. Just when the judge was about to give up on trying to ascertain the financial position of the young lad laughed and said, out loud and in the middle of the courtroom, "Ha, if they only knew I have a second bank." Just before he could finish his sentence, my fellow lawyer screamed, "I advise you to really shut up now." As to what happened next, let's just say that it is not very smart to start bragging about your second and secret bank account in front of a judge who wants to impose a substantial repayment order on you. I had a client charged with shooting and paralyzing victim. He was ID'd by a woman in the house that knew him, but the witness was potentially biased. Client says he wants to fight the case. We then discuss whether it should proceed time waived or time not waived. The difference is how quickly the case is set for trial. Time not waived means the trial is set within 60 days. Time waived means the trial can start in more than 60 days. The importance was that my client told me he was not at the scene. I stressed the importance of being honest and that everything is confidential. He again said he was not at the scene. I told him we could get cell phone records to confirm that his phone was not at the scene of the crime at the time of the shooting, and if we could show that it was active, meaning he was using it, it could help cement his alibi. I also said, but if you were at the scene, we should set this time not waived so the DA can't get your cell phone records. Client says to set it time waived and get the records. So, several months and a lot of work later, the cell phone records literally show him at the fucking crime scene at the time of the shooting. It also leads to more evidence, more directly linking him to the shooting. The records also managed to implicate his friend as being involved. It tuned the case from being borderline to a slam dunk for the DA. It's even more ridiculous than this, but it's kinda off topic. I share the details of the cell phone data with client. He has no reaction and offers no explanation for his prior statement that he wasn't at the scene. I explain that the DA does not yet have this information, so we should try and accept a deal now before the DA finds out, because he will most likely revoke the current offer when he does. Client insists on a jury trial. I explain that it's client's call whether we go to trial or not. I'm here to offer advice, and he's free to reject that advice. But I think it's a really bad idea because the DA will get the info before trial. When he does, the offer is going to skyrocket. Client continues to insist on a trial. My final words are, that's your call, but commit to your decision. If you reject the current offer, then try and plea later. The offer is going to go through the roof. If you want to plea, do it now. You guessed it. The jury is literally walking into the courtroom, and I hear this, psh, psht. I look over and ask him what's up. He says, I know you said not to do this, but I want a deal. He pled. Because of his shenanigans, his offer increased by roughly 300%. He would be out of prison if he took his original offer, and I think he has well over a decade to go currently. There's actually more, but I don't think I can share it because it's so unique that it would make it easy to identify the case.